In the relentless pursuit of financial security, Derek and Mandy had done everything by the book: hard work, shrewd investments, and conservative planning. For years, their prosperity sat plainly within reach, visible and vulnerable under the traditional ownership model. Bank accounts bore Derek's name openly. Assets were exposed like an open field at dawn, inviting scrutiny and potentially peril. In this old world of personal ownership, a storm could gather at any moment. A lawsuit, a business dispute, any of life's unexpected arrows could put their wealth at risk. If someone like Derek were sued, it was as if a creditor delighted in waltzing straight across his open field, collecting what they pleased. But Derek and Mandy, ever vigilant, decided the landscape needed changing. Their attorney counseled them to cross the bridge. With determination, they established a Family LLC. They executed a deliberate migration, relabeling assets out of their own names and into the protective embrace of the LLC. The open field transformed. Now, their wealth sat inside a fortified vault, owned not by Derek or Mandy, but by the entity, shielded from personal liabilities. The future, they thought, was secure, order established. Chaos, however, lurks in the wings of any order. A judgment fell on Derek, the result of a years-old business deal gone awry. The creditor, hungry, confident, tasted imminent victory. On paper, Derek appeared flush, a profitable business and a portfolio of investments, all linked to the LLC. The creditor's counsel anticipated an easy win, perhaps envisioning a rewarding call to their client that very afternoon. Order and chaos, nevertheless, have a way of colliding where legal structures are concerned. The charging order statute, often overlooked by the unwary, meant the creditor could receive any distributions made to Derek and Mandy, but crucially, possessed no authority to compel such distributions. It was as if the judgment came to a halt at the LLC's gate, unable to press further. In a stark, wood-paneled conference room, the battle moved from expectations to tactics. Derek and Mandy's attorney exuded calm sophistication, his demeanor scarcely hiding the edge of practiced strategy. He slid a binder, thick with evidentiary support, toward the opposing counsel with the casual confidence of a chess player in the endgame. Their attorney spoke, his voice measured. "I've reviewed the LLC's 5-year capital plan. The managers have voted for absolute reinvestment. Liquidity will be dedicated solely to internal growth. We anticipate zero distributions until at least 2030. The shift in the room was almost physical. The creditor's counsel, expecting a feast but now offered only the cent, understood the true value of their newly won rights. Phantom assets, taxable but inaccessible. The possibility of obtaining an actual dollar before the decades turned diminished to a mirage. The moral momentum of the judgment evaporated, replaced by cold reality, a waiting game that could outlast careers, even clients. Their strategy had not only blocked the creditor, but destabilized their very leverage. The only recourse was a painful choice: endure a long and fruitless wait or accept a sharply reduced settlement. Now,